we have filed a.
Today we will conclude the hearing
Yes.
because otherwise
Take
you
long.
will say that this has been heard for several days. Now, where is MS? Where MS Bora? You are here, and Mr. Kalra.
I'm here, Lord. I'm here.
All
Sorry.
right. So we'll conclude the hearing today.
Very well. Good.
We have heard it. Some part of it is in still our memory.
Yes.
It's NIOS 18 months diploma.
Diploma.
Your candidature is accepted.
Only thing
There is
not
only
subject to certain rider.
subject to certain riders. No, subject to certain further verification.
That is what I call it rider. Lord, if a lordship would kindly come, we have filed one compilation or
Compilation of documents yet filed. यहाँ भी होगा. That I think. Yeah. Yeah. This
Yes.
Now, please refer to the compilation only. A copy must be with the advocate.
Yes,
General.
yes, yes. Lord will kindly come to page 96. This is what was impugned before the learned single judge.
Yes, 96.
In view of the judgment of the Honorable Supreme Court of India, passed on so-and-so in review petition number so-and-so in civil appeal number so-and-so in the case of Vishwanath and others versus State of Uttarakhand, the applicants who have successfully submitted their online applications with 18 months D.El.Ed from NIOS against the advertisement dated 26th of December 23 are hereby asked to attend the second phase of physical document verification in due course of time when notified with the following documents in original and one photocopy set of all documents for the proof of in-service teachers as on 10/8/2017. Now, what are the documents which are being insisted upon? Appointment letter and accepted joining report. This we could furnish, my lord, because we have that. Minutes of the school managing committee of the school in respect of appointment of the applicant concerned. This is beyond our capacity, my lord. We cannot see. Photocopy of the attendance register of the school during the service period of the applicant duly countersigned by the head of the institution. We cannot. D. Certificate issued by the school authority specifying the service of the applicant in the school as on 10/8/2017. This we have given, my lord. Salary statement stating pay band, basic pay, D and other allowances of the applicant for. Lordship will appreciate, my lord, in a private school, where are the scope of all this, my lord? At the F, UDI's record as proof that applicant was in service as on 10/8/2017. So, my lord, B, C, and F.
So
we
out
could not.
of 1, 2, 3, 4, 5, 6.
Yes.
You say that
That's
four
good. E.
are impossible for you to
Yes.
furnish.
So, my lord, E is out of question, my lord. That I do not know what mind was applied to insist upon this requirement. B, C, and F we could not, my lord. A.
And you say E also because you never got salary statement. So B, C, E, and F.
Yes. So we could not.
Hmm.
My lord, just to appreciate the stand of the state government, I'll rely upon the first document in that compilation, my lord. That is a letter issued by the Government of India, Minister of Human Resource Development on 3/8/2017.
Page number 1.
Page number, please, it starts at page 1 of the compilation, my lord. Now, kindly see, it has been issued by the Government of India, Ministry of Human Resource Development to all the secretaries of education of, my lord, the states and union territories. Now, please come to page 2. Now, before, my lord, admission, this was the process which was undergone for that particular course, D.El.Ed course of 18 months. I'm reading from 7, my lord, or I'm reading from 5. State government will reach out to school principals, concerned school authorities of all government-aided private schools and inform them about this extension of deadline and publish large scale of advertisement for wider coverage. States must undertake an awareness program amongst the teachers also, clearly indicating that this would be the last opportunity for application and enrollment to the course, failing which services will be terminated with effect from 1st of April 2019, and also advise about this last opportunity on the last 7. All states should prepare a database of such teachers in their state. For creation of database of untrained elementary teachers for D.El.Ed, there will be online portal of NIOS which will have the following options: login registration by the state coordinator, login registration by individual principal at the schools. State coordinator will enter the entire database of the untrained in-service teachers in the private and government school on the portal especially prepared by NIOS for this purpose. This portal will also be utilized to monitor the progress of training in each state union territory. Now, 10 is very important, my lord. For teachers in private school, a certificate from the principal would be taken to ensure that the teacher is serving in the school. This certificate will be collected by the state union territories. Once the above information is provided to the state coordinator, then NIOS will provide the following to the individual principal for entering into the system, that is school code and password. Once the school principal receives the password and the school code sent by NIOS through SMS, then the school principal will log into the system for online registration of the untrained teachers. Then registration of unqualified untrained teachers on NIOS portal should be completed between 16/8/2017 and 15/9/2017 by the state coordinator school principal. Education services of the school's UTs are expected to ensure and facilitate this. 12. The unqualified in-service teachers in government-aided private school who fail to enroll on or before September 15, 2017 are liable to face removal and dismissal procedure against this. So, my lord, all this information are with the state authorities. Why are they putting the burden on us, my lord? Now, kindly, in the context of the case, my lord, please take the affidavit filed by the NIOS. The affidavit filed by the NIOS, it starts at page 486, I suppose.
Pull out करके निकालना.
4, sir.
Just pull it out.
486.
450, sir. 51 start होगा sir. आज तो marking जो तो कोई ले. 486. 486.
You have a separate copy. Pull out your affidavit. Give it to us.
87, sir. ठीक है sir. 487 होगा. Paragraph 3.
My lord will kindly come to paragraph 3, my lord.
Yes.
That the deponent begs to state that verification process of UDI's data of concerned school was done by state authority during the time of registration for admission. The deponent begs to state that as per order dated 10/12/24 passed by the Supreme Court of India in review petition that is so and so, the 18 months diploma obtained by such persons were in employment as on 10/8/2017 and who have completed the diploma course of 18 months be treated as valid diploma holders. That the deponent further begs to state that admission of D.El.Ed learners has been verified by the concerned school institution headmasters, principals with due monitoring by the state nodal officer. The head principal of the concerned school did the authentication of the school record. So thereafter, my lord, where is the further scope for insisting on all this? In fact, this is the stand of the NIOS. So therefore, my humble submission is, my lord, the process of verification which is sought to be undertaken by the state, it is an onerous thing. It is impossible on our part. There is no dispute that we have completed the training, we are in service on that relevant date, and when we applied for admission into the D.El.Ed course, all these requirements were complied with. Otherwise, my lord, we could not have been permitted. Now, at this stage, where from we bring it? The state authorities are themselves in possession of those documents. Therefore, they should verify from the particular schools. Instead of shifting the burden onto us, the state itself should undertake the exercise. Otherwise, the basic qualification will meet. So to deny us a consideration in the second phase of the selection process, then it will be an arbitrary enactment. I don't think there is a further requirement necessary for this, because we say that the verification process which now they have stated.
What has the learned single judge said about it?
Yes. Single judge's order.
We'll find it in this compendium or we can go to the file?
No, it will be in the second volume, the single judge's order starts at page number 368. Yes. My lord, the judgment, it's a long one. It starts at page number 371.
Where has he dealt with this?
Yes.
Second volume of this appeal. It's undone. School पर में तो okay. It's only one ऊपर में होगा. Come to the internal page.
Para 34,
Para 34.
at internal page 63 of the judgment. Otherwise 433.
It's a huge judgment. Yes, 16.
Before that, I'm very sorry, Miller. I may be permitted to place two paragraphs, Miller. Para 22 at internal page 53.
Yes.
It is thus clear that the apex court in the aforesaid judgment in review petition and connected cases categorically emphasized that in-service status of applicant as of the cutoff date must be duly verified before treating them as valid diploma holders under the advertisement. Now, it is nowhere said, Miller, it is not correct. Verification of service status is therefore not an optional formality, but a mandatory step flowing directly from the apex court's
At this stage, can we just have the order, the review order?
Yes.
Which will be there in your compilation.
Yes. That review order, lordships will get
At page 61 of your
90,
compilation.
90.
yes, 60.
60. Yeah,
Please
yeah.
come to page 88.
80?
87.
Hmm.
We therefore pass the following order. The appeal is allowed, etc., etc. Lordship may kindly come to Roman 5. We clarify that such of the teachers who were in employment as on 10th of August 2017 and who completed 18 months D.El.Ed program through NIOS before 1st of April 2019 shall be considered as valid diploma holder for the purpose of applying in other institutions and or promotional evidence. Then below next para, we direct the respondent authorities to consider candidature of such of the appellants who were in service as on 10th of August 2017 and that too on verification are found to satisfy the eligibility criteria shall be appointed within a period of 3 months from today. Well, the verification which is indicated in at para Roman 6 is not the verification which is now sought to be done by the state. Verification means verification at this stage when they took admission. Otherwise, it makes no sense.
Page number 88, 89 and 90, so that is the order of review. Order of review is page number.
It will.
Then complete this paragraph number 22.
My lord,
paragraph 22 of the judgment
Yes.
issue must be verified. Now, so this is, I mean, that a different process of verification was adopted, you can argue.
Yes.
But the contents of paragraph 22 of the impugned order is not incorrect.
No, because paragraph 22 in my humble submission it does not emanate from the observation of the Supreme Court in the
Right,
review.
the review petition.
Because
correct.
in the review petition,
No,
to
no,
my
it
humble
says-
understanding,
It's a very carefully worded paragraph. It says it's clear that the apex court in the aforementioned judgment in review petition and connected cases categorically emphasized that the in-service status of the applicants as of the cutoff date must be duly verified before treating them as valid diploma holders. That's what internal subpara 5 and 6 would say. That because you are being given the concession of being treated eligible even with 18 months in diploma.
instead of 2
years.
years, Miller, it should be
18 months, and those 18 months clarification has to come if you were in service on that date in 2017.
If we would not have.
That's all right. So therefore,
I'm just trying to.
you are, Mr. Chaudhary, you are trying to find fault with the government asking for certain documents from you.
Yes.
But so far as this statement is concerned in paragraph 22 of the impugned judgment, it's not factually incorrect.
No, what I'm trying to submit, Miller, it's something like this. Unless we comply with the requirements,
Well,
it's
that's
not
true.
been admitted.
Oh, therefore, your prayer is more than adversarial. You say that you please check up, and if we don't fall in that category,
Yes.
but remove us.
The
Don't
data,
consider.
data is available with you to please verify. Then Miller para 20.
Verification is a must, because otherwise anybody in collusion with the principal who gives a certificate, UDISC code is given and then it happens. Unless you were teaching on that date.
Minimum of the verification has to be undertaken, that we're not disputing. But only question is certain documents to say that give us the pay slip and all that is beyond our competence.
Therefore, Mr. Chaudhary, there is a pitfall in your argument. Not pitfall in your argument, I'm sorry. I mean, let me frame it in another way. The process that you're suggesting could be more dangerous for you. Now, if you say that, well, let the state is the custodian of all records, whatever has been done, the state has it, let you verify. The state will say that these documents are missing, we don't know. This is only for ensuring, just a minute, Mr. Chaudhary, just take yourself away from the facts of your brief.
In the ultimate analysis, our argument is very clear enough. Since you have already undergone this process, there is no further.
That would be a very difficult proposition for you to converse, because the review also says whatever was done, if it was under cloak and dagger, if it was under stealth, if there is a possibility of an accusation that it was obtained for the purpose, which is just a minute, let me complete. Which is not
such is the instance.
Just a minute. So we say, then please don't question. If you don't have these documents, the state will verify. The state will say, Mr. Chaudhary is not eligible. Would you accept that position?
Then we may have to come again. But the question is whether once you have undergone the exercise, can you still insist upon it? And that to be Lord.
Just a second. Now, do we ask the state here at this moment that if they leave it to your goodwill, that you will not, Mr. Saikia, that you will not unnecessarily discriminate them? You find out from your records, you find any document missing. If there is any doubt, remove them.
The record.
Ready? Are you ready for it?
I will be more than happy. because why I am saying it is from the record in the court before dishonorable. They are saying a different story.
We don't even go on that reason, Mr.
The record is before this honorable court, and from that record, they will be all thrown out. On oath, they have said something which is very dangerous to their.
So therefore, now instead of having a decision in their favor or in your favor, they are agreeable that you decide from your records. You decide and take a call. Mr. Chaudhary, you will fall in the trap.
So another round of repetition will come up, nothing else. Because we cannot ignore some documents which they have against the repetition itself.
Advocate General, Mr. Chaudhary is ready.
Yes.
That the state must verify from its own records. They don't have.
I'll be more than happy, Lordship.
We conclude. Yes, Mr. Kalra.
Yes, my lord, it's grateful. Just 5 minutes of time I'll take, my lord, because I had the occasion of assisting in the review as well as before the learned single judge. Some factual aspects I wanted to make clear, my lord. So there's a short compilation of orders and something that has transpired post the impugned order. A recent Supreme Court judgment on the same very issue has come, but for a different state. I wanted to just tender that and show 2-3 things from that, plus also give the background that why this 10th August 17 and why this verification, because as I said that I had argued the review petition before the Honorable Supreme Court. So I just want to assist my lords that what was flowing in the mind of the Honorable Supreme Court while giving this decision. So if my lord can just have that compilation, my learned friend will just tell it.
Kalra, we don't have any objection to hearing
Lord.
this aspect of the matter, this legend.
Lord.
But in view of what Mr. Chaudhary
Lord.
has said
Lord.
and agreed to by the state that they will not insist for these documents, they will have it tested from their own records. And then they will take a call. If it is subject to criticism, subject to scrutiny, you can come to this court again, but don't insist for removing those clauses. If you do, then believe on the statement of the state.
My lord.
They will process it, they will find it, they will issue notice to you if they feel like, otherwise they'll reject your candidature. If you are aggrieved, come back to us again.
So I'm going a step ahead. Just bear with me for just
So,
2
but why do we ask you to go a step ahead? Because this is a major concession by the appellants.
That is true, my lord, but I'm just trying to answer.
There can be only two ways in which, I mean, there is no third way in which a cookie would crumble.
Indeed, my
One,
lord.
you furnish all the documents.
Indeed, my
The
lord.
state will see whether these documents are genuine or not.
Indeed.
If you say that you don't have the records, it is all with the state. Let the state take a call. And
Very-
in that case, you challenge. Where is the third way?
Yes. Can I just add on to this? There is no third way, my lord. There is a midway to both of these things, which I can just answer.
Midway. Yes.
My lord, I just wanted to show from the compilation this fact that when this admission was done, because this was a one-time course, all India one time. It is not just about state of Assam, the entire country did it. The documents say, which I just wanted to show, that unless the state coordinator enters my name, I had no access to personally apply. This is not like a private admission where I can go give my form and take admission. The documents as well as the verification in 2017, which I will show, says that unless the state gives my name, I can't take the course.
Agreed.
So therefore, it is like putting the cart behind the horse.
And if you look at it from the angle of cart before the horse or horse before the cart, then perhaps situation will be different.
Indeed.
Question is this. You say that according to the system generated then, every record is with the state or NIOS.
Indeed.
NIOS also depends on the record which is present with the school.
Indeed.
The school is under the direct administration of the state in its education department.
Indeed.
Therefore, the only concession by a judicial order which could be given to you is that, well, don't insist for all these documents. You take a call from your archives.
Sir, nodal officer, he should have with all these documents. If the nodal officer did not had not received all these documents, that will be the end of the story again.
No, I'm sorry, my lord.
That
That is
observation I would like to have from this.
no, that is something different.
That
That is
the
what.
nodal officer, while enrolling them in the portal, he was supposed to have all these documents. He has not taken.
So you
And again,
No, no, that's something
have to
different.
spell it out, Mr.
we'll have
Saiki.
to have speaking order again.
Just spell it out here.
I'll make my.
No, the ball is in your court.
Yes.
You take a call, decide. They will question your decision individually.
Yes.
Sorry, slightly different, my lord.
That is what, that observation I would like to have in this order.
No, my lord, that is slightly different. We are going to a different tangent. Just respectfully allow me 2 minutes, my lord. I won't take more than that time. My lord, no one is against verification. I must make it very, very clear, and that is what I argued before the learned single judge also. The idea of bringing 8 new documents for the first time at this stage is something that we are challenging. The reason is this, my lord, that when the Honorable Supreme Court, and this is not the first order, at least 8 states, 9 states have implemented it. I put that orders on record. They have implemented on the basis of one document. What is that document? The experience certificate. And this experience certificate is not because of my convenience. The MHRD letter that was read, my lord, in 2017, when I had to take admission, the MHRD while framing, because MHRD is the regulatory authority under the NCT Act. They say that for proving that you are in service, because this 10th August 17 was a cutoff date, as the amendment to the RT Act was notified on 9th August. So the MHRD, while bringing this course into place, said that for proving in service, you have to give an experience letter. That is what the MHRD says.
Mr. Kalra, can I stop you here?
My lord, certainly, my lord.
You see, the review order and the main order of the Supreme Court
My lord.
they directly and indirectly they talk of verification of records. Otherwise anybody can claim 18 months.
Indeed, my lord.
Correct?
Indeed.
So the state might not have had been so clear, they
Indeed.
would have taken a decision themselves.
Indeed.
They're asking for the documents from you only to reassure the candidates that their candidature would not be thrown aside lightly.
Indeed. I'm so grateful for this question, my lord. I'm so grateful.
No, this is not a question. This is just a formulation.
Indeed.
Now, therefore, if you think that these are impossible to obtain
Indeed.
at your end,
Indeed.
impossible to obtain,
Indeed.
let it be decided by the state from their archives.
I will just directly answer
And
that.
then if it is questioned, you come to the court. But
I'll
why
direct-
challenge? There can be only two ways. That's what I perceive.
Yeah, can I
Broadly.
directly answer that, my lord? My lord,
Yes.
my lord rightly put to me that the Supreme Court's original order and the review order give a class, that the class has to be ABC.
And
I am
secondly,
going.
I must state what was followed in some other state
My lord.
may not be a precedent.
I understand, my lord, but can I
May
just
not be a precedent because every state has its own problems. Every
Very well.
state has its own specialities.
very well.
Like say state of Bihar or maybe state of Assam
Indeed,
would
ma'am.
not be able to follow the same way as the NCT of Delhi, or no,
Indeed.
it is not NCT now, it is the state of
Indeed,
Delhi.
but I am on a slightly higher footing, my lord. After that, the Honorable Supreme Court has passed two orders, which, in my humble submission, will bind the state of Assam for this same very purpose. That what document can be asked for? All
What
that,
is there?
Yes,
What is
that's
there?
what I wanted
Yes.
to. Please see that. Can I?
This is an argument which you will hear.
Yes,
Where is that special?
Please. Can my learned friend just tender the compilation, my lord, of the recent orders after the impugned order that has been passed? After the impugned order.
Can you just tell us the page?
Yes, my lord would kindly come to page number 1. Document 1, page 1.
Hmm.
My lord would see the second paragraph. Transfer petition numbers are mentioned at page 1. Transfer petitions 1052 and 1404. Lords are having that?
Yes.
Lord would just make a note. Transfer petition civil 1052 is of Telangana. And 1404 and 1406 is of Odisha. I will show that.
Okay. We
Then
believe.
please see para 1, my lord. This court, in the case of Jaiveer Singh and others versus state of Uttarakhand and others, reported in 2023 so-and-so, which has been substantially relied upon from time to time, held that the candidates who were in employment as on 10th August 17 and who had completed a diploma of 18 months would be treated as a valid diploma holders for the purpose of applying in other institutions for promotional avenues. Then see para 2, very, very important. In the present matters, it is not in dispute that the petitioners were in employment as on 10th August 17. Just bear with me. I understand what is following, my lord. This, my lord, is said on the basis of one document before the Supreme Court. Kindly see, my lord. Please come to the next very page, which is page number 9. Page number 9. My lord would see page number 9. I have annexed the transfer petition. What was there before the Supreme Court to give this finding? Please see page number 9. Page number 9, my lord would see, is the cover page of the transfer petition to tally the number. That I have annexed the right transfer petition. In the top, it says 1404 and 06 of 25. Then please see, my lord, what is the supporting document that was annexed. My lord would kindly come to page 18, 18. Page 18.
Yes. This one
Experience certificate. So, my lord, on the basis of one document that I have filed before the Honorable Supreme Court in a different state, the finding rendered is undisputably we were in service. There is no other document. Plus, going ahead, and plus, my lord, here the finding that comes is please appoint them. I am going a step ahead.
We are not getting persuaded by this argument.
Can I just go a step ahead? Then persuasion will come, my lord. This aspect of whether there should be more documents or not was challenged in a review. That has been dismissed yesterday. The review has been dismissed yesterday. The order is ready. We are tendering the copy of the order.
The petition was filed by the state,
By the state of Telangana. That has been dismissed yesterday. The order has come out. We are tendering the copy of the order. The copy of the petition we are extracting because it has been dismissed yesterday itself. So to file, we need the certified copy. And therefore, and plus, my lord, I'll go a step ahead. Contempt notice has been issued after.
When would you obtain that?
My lord, in a week's time.
That would have a very important bearing on
In a week's time, my lord.
we were now contemplating to dispose this petition on.
In a week's time, my lord. In fact, my lord, on the basis of this order, because this order which I read, undisputed.
See, once you raise a point and that catches our attention, then wait for the court to respond.
Yes, very well.
Let me ask the learned advocate general, Mr. Saikia. Now he says the matter has to be verified. He says, up till now, what orders he has shown, I don't know whether that copy was given to you.
I have just seen.
You have seen it. So those mean nothing to us. In that circumstance, this certificate, there was no objection that this certificate is false or this certificate is through proper source or it is there in the record. They said that all right. Therefore, thereafter, these respective state in their education department, they sought permission because this was a very closed-ended order. It did not leave any scope. So they asked for permission to verify further by asking for more documents. And that review was dismissed. Now, if the review was dismissed on technical grounds that this was not the issue here, why review? Then perhaps he doesn't have any, this argument does not hold water for us. Otherwise, then we wait for it. 1 week, he will give us
No
the petition.
difficulty because whether the challenge there was like a notification which is put to challenge Mr. Lande's
That's
signature.
right, that's right. And then
That is the issue.
in all its probability, the review would have been dismissed on the ground that this was not the issue in the main petition and therefore the review is not
Whether they have
maintained.
identical notification.
And that's a separate cause of
So
action to
second
file a writ
there.
petition. No clarification is required. We don't know.
Let us wait for 1 week.
One more.
As far as our
In any
perspective
case,
is
nothing is going
concerned,
to happen during this model code of conduct.
So let you give us Mr. Kalra by next week.
Very
We
well.
are- We are in a hurry to dispose it off because we have heard all of you thrice. Don't want to keep
And
it further.
in our case, everyone has a different story to tell here.
No, we'll adopt the
They
principle.
have also enclosed some certificates which are itself doubtful.
Just a minute.
Prima facie.
Prima facie, Mr. Kalra and Mr. Chaudhary,
yes,
we are of the view that verification is a must. Without verification, if they do, we will catch their neck. Because
That will be a violation of court's order.
violation of court's order and then violation, the entire purity of the selection process would
In
stand.
fact, Lordship, 400 have applied under NIOS, 300 have cleared. Only these are left out.
Just a minute.
They have produced all the documents,
So,
but genuine.
Therefore, Mr. Chaudhary, so far as verification, just a
if the
minute.
verification.
Let me just
says
complete.
There's some nexus with the object sought to be achieved.
नहीं,
it's well.
इसमें nexus वाली argument नहीं लगाएंगे. The verification has to be done. If they don't verify, they are shirking away from their responsibility as an employer.
Why?
1 second, let me.
Why have we made that
let me-
argument?
let-
Because
you have rightfully made that
Yes,
argument, and
yes.
please hear what is passing in on them. Verification you can't question. Nobody can question. It has to be verified, whether it is by virtue of a review order or court's order or no order. Unless the eligibility is verified, how can
therefore,
Yep.
we are also not prima facie against verification. But all that we are trying to say is, we have already undergone this process once. That is how you got us admitted.
That is what-
Why are you insisting on it
Yes.
again?
So that is what we are telling.
That is
But
so late stage.
the state in this instance appears to us to be very, very transparent. But look, if you have these documents, we will not question it. On the basis of this, we will clear you. If you don't have these documents, rely on the archives of the state.
No, whether it is transparency or something else, I reserve my comments. I'll make it up the next
On
day.
paper, what we see is this. On paper, what we see is this. On the contrary, any defensive action that, well, it was done once, why do you want to do it twice? Don't you know of the instances where after 10 years it was verified and found that the entire record was
In a quoted case, it can- but
therefore
but the manner in which the exercise was undergone.
no, we are
And
prepared.
these are all database.
With-
Therefore, where is the
Agreed.
scope?
So with the concession of the learned advocate general, we would not insist. We would not ask the government to insist for all these documents, but we'll definitely say that you check up from your record if they are not.
101%.
Very well, very well.
Take a call, Mr. Advocate General.
I'll definitely during this 1 week, I'll also find out what are the documents the state nodal officer. There was only single nodal officer who was enrolling about
They
50,000
cannot say this.
persons during a period of 20 days or 25 days.
So,
It is not possible. He did not have the
Mr.
mechanism.
Chaudhary and Mr. Kalra,
Lord.
if that document is not available on record in the state archive for whatever reason, database or whatever, can we force them to accept your candidature? The question is this. Now you remember
In
of
that case, the benefit of doubt cannot go in favor of the state.
no, no,
No,
this is
it-
criminal. No, this is not a criminal case. Nothing.
This is not a, this is not a
Where
typical
is this
LBW
benefit?
petition.
Sir, benefit of doubt theory is wearing thin in the country of its origin. You are applying a completely alien doctrine in this service effort. There is no failure of doubt. There is just a minute. Raz,
Once it is database,
once
where is the scope?
now you have raised this issue. It's a hornet's nest. Now hear from me. Rajdev Sharma 1, Rajdev Sharma 2, Rajdev Sharma 3. These are three important cases from the state of Bihar. If the records are missing from the archives of the state, everything goes. Clear. Supreme Court is very clear that no High Court should interfere and no, don't show any compassion. If the records are not available, it's the end of the matter. Then question how irresponsible the state has been. Question is this. Yahan benefit of doubt wali theory. Benefit of doubt theory, if you start using in selection, the benefit of doubt has to go to you. The examiner was very strict. So therefore add 5 more marks. I mean, you can't press this. I mean, I know you just said it casually, you never meant it.
No, just to add on to that, my lord, just to add on what my lord was saying, had these documents been asked from us 8 years back, they were absolutely justified. None of these documents were asked from us 8 years back. Had I known these eight documents would be required, I wouldn't have taken an admission that time, or I would have arranged. Now, most of those schools have closed.
This argument reflects your genuine concern, but it is not possible to accept.
Because most of those schools have closed. Most of
Just
those
a minute,
schools have-
appointment is being given now.
My lord, it is not for the first time. My lord, this is not for the first time that I am
Suppose
getting.
today I have lost my matriculation certificate.
My lord,
There is some doubt about my age.
my lord,
Now I'll say that you did not doubt it, then I have lost it. Now what do I do?
directly answering that.
That's very difficult. No.
Class of my people are
What is
not
this?
getting appointment for the first time.
What is
We have
this?
been appointed in previous recruitments also in 2021 and 2023.
If the Supreme Court
My lord,
says something on merit, that in a case of this kind,
my lord,
like us, see, I'm again making a comparison wrong.
my lord, my lord,
May
lord,
not be as apt.
lord,
The law with respect to assessment of age of a juvenile,
lord.
it says that please don't insist for all arguments. First, matriculation certificate. If
Indeed.
not, last school attended. If not, this. If not this. And then the last resort is assessment, ossification test. Now, likewise, here, these are the tests.
Indeed.
Now, if you don't have the documents, let them make that ossification test from their records.
Indeed, indeed. So grateful for this example. If the matriculation certificate is not available, then we go on to the second. The same thing we are arguing. If the experience certificate is not available, or you are saying it's not genuine, then let us go to the second.
Mr. Kalra, I quite see that you pick up on an argument, but then that section 94 analogy cannot be drawn here. That is the law, which will not
I'm saying that option 2, option 3.
We are quite impressed by your, ad hoc, ad lib arguments. We are impressed. But then what I was talking was section 94 or section 12 of the rules of 2007.
Indeed, my lord.
Nothing is there. Therefore, at best, we will see the order of the Supreme Court in review. What did you ask for? And what was the reason on which the review is dismissed? If the review is dismissed summarily, no grounds dismissed, then we will not take it into account at all.
Yes, we will produce the order and the review petition of the state, my lord, because the order it passed in our favor was that please appoint them on the basis of this experience
Or
certificate.
otherwise, accept the proposition that you don't have the records, you are very genuine, all records are with the state, let the state verify and they will give you individual, they will give you reasons
No,
that
can-
your candidature is being rejected because of this.
No, can it be passed over? We'll take instructions and come back, my lord.
That's how it should be done. I mean,
Very well.
unnecessarily verification, who can question?
So, absolutely no problem, my lord. As I said,
The learned single judge ought not to have gone in such detail. Either there is verification or you believe in them.
indeed.
My submission is that why Supreme Court had used that concept of verification.
Yeah, yes.
If they are happy with 18 months D.El.Ed course, that is the end of the story.
I go a step further.
And has been
Even if they
inserted
would
there
have used, my lord,
and
state is
verified.
rightful in
We
their
go a
right.
step further. Notwithstanding any order or no order from the Supreme Court, are you not supposed to verify?
We have to. I have some judgments on that line, Lordship. I have brought
Look,
those.
we are not, no one's questioning
For
the
any kind
verification.
of promotion or any kind of
Because
appointment,
single judge-
verification you don't have.
Because
to
the
get
learned
service
single
through.
judge, because the learned single judge, in our opinion,
Lord.
unnecessarily went into that issue. Question is this: either you accept our assessment, either you accept the assessment of the employer, or you furnish on this.
Lords, can I make one suggestion if that will please my lords? My lords, I wanted to show from the compilation also that all the names of us was given by the state to NIOS. Can a direction be given to them that let them file the data that they gave to NIOS within a period of 1 week? Everything will be clear. Because the data was given by them. I, as a personal individual, cannot apply. That is the law.
That is understood. NIO, see, the difficulty is that the verification is that stays also. Look at the affidavit of NIOS.
Lord.
If you don't go further, because it might create further problems. There could be an inquiry. Now, NIOS says that we have entertained such students for 18 months diploma only on the asking of the state. Correct.
Indeed.
So you cling on to that. The
Indeed.
moment you ask for the details, then Mr. Advocate General will say that look at this. This officer who was present that time, he cleared the name of 50,000 students in 10 days. So if you want that, we can have an inquiry conducted. In the meantime, you shall not be considered. You want that?
No, absolutely no.
Therefore, if I
80% of the NIS candidates were all inducted.
look at that, there are
Only
some-
20% are
therefore
left.
we said that pursuing it any further
Very good.
might result in another criminal proceeding. Therefore, wait for them. They have nothing against you. The state would not even know your names. To be hostile to you. Definitely not. If
Certainly
they-
not, my lord. That is something we expect.
Even if they want, they can't. For
They
the
can't.
reason that you are in big number.
Indeed, my lord. Indeed.
They have no axe to grind against you. So
Indeed.
therefore, let them decide. If you want an inquiry, the Advocate General is more
No,
than.
my lord, we are concerned about our jobs, my lord.
He will start an inquiry and he would be.
We have a very
police
professional
inquiry
team.
also.
No, it will be never ending, my lord. We want our jobs, my lord. We don't want it.
It'll never.
And conviction rate is also very high.
Never ending.
It will be a never ending situation. Then the Advocate General, without seeking any permission, he will seek permission only till the time the matter is pending. Otherwise, he will say that this is good for police inquiry. Don't get into all that.
Very well.
My experience here has been like this.
The principals will be in deep trouble because their certificate which they have annexed, if I place it, Lordship will get astonished.
No, but we don't want to trouble them. They have come for some benefit. We will not
Yes.
take
No, the
away
principals
whatever
who
is
issue
present
those
with.
experience certificates.
Shall we? Dekhte?
No,
Let's see. Yes,
we'll
Mr.
not have it. We'll not pass it over. Have it tomorrow. We'll take instructions and come back. Whatever is convenient.
Tomorrow, so you can give us that order, no?
So the order I can give, the review petition, I will try to get
No,
it
order
today.
means nothing. Order would be one.
The review petition I will try to extract in at least a week's time. I'll try in 3 days, my lord. If I get it
Next
before,
week.
very well.
Next week, Lordship.
So immediately after I come back from Bangalore. When do I come back? 22nd. 23rd को कर देते हैं. I come on 22nd. No? 23rd of March.
No difficulty, Lordship, from me.
23rd is Monday, Tuesday.
Yes, no problem.
No, we will keep it Tuesday, 24th of March.
Because there's some IAS for implement that may be disposed of at least.
And that we will dispose it off on the same day.
Very well, very good.
We will decide the petition. You come with a specific, instruction.
Certainly, my lord.
Your case. If you come with a specific instruction, we will deal with your matter in a different way. If Mr. If Mr. Chaudhary doesn't agree, we will.
No, my lord, I'll go by my statement, my lord. Let them verify from the available materials.
You're ready?
Why I say
You're ready
so,
for
then
it.
I'll also
Yes.
substantiate on the next day.
Correct. Mr. Kalra, if you're agreeable to this of Mr. Chaudhary, we dispose it of today.
Lords, can it be passed over? Can it just take instructions and come back? Can it be passed over?
Today it may not be possible. He is representing some of the appellants.
It's same.
He is an intervener.
He is an intervener. Nonetheless, we have heard him.
No, certainly, my lord.
His any order in his against him or for him will not bind you. I mean, we will do it. General principle we will evolve.
Very well.
Let's keep it on. Take a call. Come prepared. That day only argument. Mr. Chaudhary has been very clear. He says that now the state must do it. Don't insist for these documents. The state will say we will just impose one obligation on the state.
Yeah.
That if you if you reject their candidature and say
We
that they are
will
not
pass a speaking order.
short order giving reasons, speaking doesn't mean 5 pages order, not the history. You are, this appears to be spurious. We don't believe this. This is deficient. End of the matter.
And in the meantime, I will also obtain instructions. I am not filing affidavit. What procedure they followed, the state nodal officer followed at that point of time
That's fine.
while enrolling it. That is just for information and apprising this honor.
After some arguments, after some ऐसा नहीं था. Arguments to continue. Let all these matters be listed for final determination on give a date on Tuesday. 24th.
Lord.